about compliance obligations. What key compliance obligations should H-1B employers be aware of, particularly regarding wages and also work location changes?
That is a great question, and it actually gives me an opportunity to spend a quick moment on something that we were actually notified of by a client the other day. So, one of our clients actually called us up last week and said, we've seen an increase in site visits, but what's weird about this increase in site visits is they're almost all going to people's homes if they have their home address on the LCA. And it's not just an FDNS officer, it's also a DOL officer. So what they're doing is basically FDNS, if you know how to work the system, you can rationally push back against certain pieces of evidence that FDNS requests that are pay related because that's within the purview of DOL. But now what they're doing is basically bringing both agencies together during site visits or investigations to say, oh, well, you think you can't hand over, you're not going to hand over your pay records to us because we're FDNS. Well, here's someone from DOL, and you have to hand over your pay records to him. So anything that you think you can hold back, you can't. The point of that is to say this: compliance is it's key. It is key. The Trump administration has laid down the gauntlet that their favorite word over these past 3 months, whether it's Doge getting rid of wasted spending or the H-1B program or whatever it is, fraud. Fraud, fraud, fraud. They want to find fraud because it justifies what they're doing. It justifies the increased FDNS site visits. It justifies the increased visa revocations, RFEs, all of that. It's necessary for them to prove their work, and they're going to do that through the consulates and here in the States through FDNS. So when it comes to compliance, I mean, you're going to have to be complete. It's paramount. It's absolutely paramount. I wouldn't be shocked if, amendments filed 3 days late end up getting site visits. And if they're able to connect the dots that a person started a project early, turn around and revoke, that wouldn't surprise me. People need to be working where they're supposed to be working and being paid the wage that they're supposed to be paid. And if either of those things are incorrect, if the wages are wrong, DOL is going to be coming in some capacity, or should be. And then if the person's in the wrong work location, then you're dealing with a potential visa revocation. And as I say every time I'm on here, they really are trying to push the fact that deficiencies in the LCA constitute a material misrepresentation, which means a finding of fraud or misrepresentation. Now, that's not even necessarily true because fraud requires someone to make a statement to an immigration officer that is, untrue or willful misrepresentation at the time they procure the immigration benefit. So if somebody actually does work in location A and then they move to location B and the employer doesn't file an amendment, it's technically not supposed to be fraud or misrepresentation because the original petition was true. All that is to say, USCIS doesn't care. USCIS is willing to say, no, we think that's fraud or misrepresentation. And remember, fraud or misrepresentation carries with it a permanent bar from the United States. And the only way that can be overcome is through a waiver acquired at the consulate or through litigation in which you sue the federal government to have the fraud finding removed from your record. Both options take time and are difficult. So if there's any way to avoid them, it's compliance. It's ensuring that everyone's working where they're supposed to be working, getting paid what they're supposed to be getting paid, and working on the right project that they're supposed to be getting assigned to. So yeah, I think that was a fantastic question. I think compliance is going to be huge. It would not shock me at all if we saw, here's a tidbit to you that I'll give you. Something I think that USCIS is going to do. I think USCIS is going to approve a bunch of H-1Bs for consulting companies for quota. I think they're gonna do it. I think it's gonna be a lot of cases that they're gonna put through and say approve them, approve them, approve them. Those cases are going to get site visited the first week of October. I think the very first week of October they are going to site visit consulting companies at a high level because they're going to look for the consulting companies that filed generic petitions that did not assign individuals to a specific project and then go after them to say, you didn't have actual work available on day one, like you said. This is a deficient petition revoked with a finding of fraud or misrepresentation.